Ulmer. If you can go ahead and we'll just do what we always do. Go ahead and state your name and readiness to proceed, please.
Sure. Sarah Nelson on behalf of Mr. Ulmer, ready to proceed.
Good morning, Your Honors. Megan Woodall on behalf of the City of Cincinnati, also ready to proceed.
Okay, thank you so much. Whenever you're ready, and also let me know if you'd like to reserve some time.
3 minutes for rebuttal, please.
Thank you.
Thanks. Good morning again. May it please the court. Sarah Nelson on behalf of Mr. Ulmer. This court should reverse the trial court's decision overruling Mr. Ulmer's motion to suppress, as Mr. Ulmer was stopped without reasonable articulable suspicion that he was committing an offense, or alternatively because his car was searched without adequate probable cause. The state argues that this case concerns a consensual encounter, but a consensual encounter occurs when an officer approaches someone in a public place and after engaging with them, the person would still feel free to leave or otherwise terminate the encounter with the officer. That's not what occurred.
Nelson, with regard to the stop, because you started at the stop, with regard to the stop, I noticed that the court didn't make any findings of fact or conclusions of law with regard to the stop.
Respectfully, I think in the first motion to suppress hearing, the trial court did find that this was a stop for trespass. The court was very much focused on the search of the vehicle, and there's a lot of talk about the relevant case law, but there was a statement made that this was a stop for trespass.
Okay.
So relying on that legal conclusion and the facts between the Officer Ruberg's testimony and the body cam video, I would argue that this was clearly, the factual circumstances suggest this was clearly a stop for trespass, not a consensual encounter. Particularly because this happened on private property and they were alerted to Mr. Ulmer only because he was sitting in a parked car on private property. They approached him.
Ms. Nelson, was the testimony though that as soon as they approached him, they smelled an odor of marijuana coming from his person?
Yes, that's what he testified to. However, the body cam video shows that there was an engagement, a discussion preceding that about his trespassing. Officer Specialist McGraw specifically discussed with Mr. Ulmer that he's trespassing unless a resident is escorting him onto the property. So the whole approach.
Was he detained at that point?
He was detained until the admission to smoking and the minor misdemeanor amounts of marijuana that he admitted to having on his possession, which is not an arrestable offense. So I would submit that they were handcuffing him on the basis of the trespass violation in addition to the marijuana.
How far away was he from his car when he was stopped? Do we know that from the record?
It seems that he had just exited his vehicle, that his vehicle was just behind him. I believe it's the one that Officer McGraw is standing next to, although I'm not certain about that. So in my view of the body cam video, Officer McGraw is cutting him off from access back to his car, and that Officer Ruberg is precluding him from traversing up the steps into the apartment complex. Again, facts indicative of, seizing somebody, not a consensual encounter. He's not free to leave under these circumstances.
Well, doesn't the officer sort of acquiesce to that and say that he stopped Mr. Ulmer before he entered into the building?
Yes, he said that they confronted him before he could walk up the steps. So again, factual testimony supporting that this was a stop, not a consensual encounter. Was there another question? Sorry. Okay.
I think you answered it by that answer. Thank you.
Yes. Okay. So again, the factual circumstances in this case suggest that no reasonable person would feel free to leave or terminate this encounter, rendering it a stop, because the officers pointed to no particularized activity with respect to Mr. Ulmer committing any type of criminal offense, including a trespass. There was no prior interaction with Mr. Ulmer that he had ever been trespassing before. He was not engaged in other criminal activity prior to their approach. Under these circumstances, there's no reasonable articulable suspicion to engage in a stop for criminal activity, which is why
did trial counsel argue that at the suppression hearing?
It was argued in the motion to suppress. In the first motion to suppress. So in this case, I mean,
on what was actually heard, not the written motion, but the issues that were heard. Yes.
So Yes, and post testimony arguments, the arguments seem to be very focused on the search of the car.
What
But
about, I mean, but was it argued that the initial stop was improper?
not explicitly outside of the motion to suppress.
Well, when you say outside the motion to suppress, there was a hearing on the motion to suppress. Was it argued at the hearing on the motion to suppress?
No, not explicitly. But it,
Was the written motion one of the boilerplate motions that are filed that have all the language in about suppression, or were there specific facts related to the stop in this case, the initial stop? That's okay. You don't,
I
you don't
can
have to read through it. I can go back and look.
I can address that on rebuttal, so I have a chance to glance at it. I don't recall off the top of my head. I just know that particular legal issue was asserted in the initial motion to suppress. It wasn't explicitly argued in arguments after the motion to suppress hearing, and it wasn't raised again when the trial court narrowed the issue to the search of the trunk in the supplemental briefing. But with respect to the state's argument that this is waiver, because I feel like this is what these questions are kind of aimed at, I would submit that this issue was put before the trial court, and the trial court did make a ruling. Again, everyone seemed to be very focused on the trunk, and I know that it's easy to skip to that, but I think there are circumstances here that suggest that this was an illegal Terry stop.
Ultimately, the motion to suppress is solely seeking to suppress the firearm. Is that correct?
Well, with the exception that they also challenged the Terry stop, the second supplemental briefing did only address the search of the trunk. That's correct.
No, I'm not asking about how we get there. I'm saying that the only item that is sought to be suppressed is the firearm.
Oh, if I could double check that on rebuttal. What I'm getting at is, like, in the initial motion to suppress challenges the stop, and that's why I think the issue is preserved. But I agree that the argument sort of devolved into the suppression of the firearm into the trunk. And that's what the supplemental briefing, the second motion that was filed, really focuses on.
No, the point I'm getting to is, if the stop was an unlawful Terry stop, then that suppresses the firearm.
Correct, yes. And also,
if the search of the trunk was an unlawful, warrantless search, then that also suppresses the firearm.
yes, correct. I would also add that the Terry stop would also suppress the drugs found on his person, because he was also charged with drug possession and the trespass violation as well. But I agree that the argument ended up with the firearm, and the illegal Terry stop, in addition to an illegal probable cause search, or a search of the vehicle not supported by probable cause, would suppress the firearm.
Okay, because the trespass, I don't believe, has been challenged.
Well,
That's my reading of the record, is that the trespass has not been challenged.
okay, I understand. I was sort of misunderstanding.
Yeah, and my reading of the record, I don't believe the possession of marijuana, the marijuana that was found in the interior compartment, is being challenged.
I'm agreed. I would agree with that characterization of the record. What I'm arguing, though, is that I guess this technically would be waived then, but by putting the Terry stop in the motion to suppress, I think would bring all of that back to be subject to suppression, just by everything that follows would be fruit of the poisonous tree. But agreed that the argument was focused on the suppression of the gun.
Can we get into the, let's move beyond the stop and get into the smell of marijuana.
Yes.
It sounds like from the record, he reeked of marijuana. He admitted he had been smoking in the car. He admitted he had thrown out a burning marijuana butt onto the ground. And the officer not only testified that he smelled marijuana coming from Mr. Ulmer, but also coming from the vehicle. So how do you get around the Moore case that says there's probable cause to search on that basis?
I think the holding in Moore requires a factual predicate that the officer must be qualified and trained in detecting the odor and smell of marijuana. That factual predicate is very important in this case because it's unclear whether he smelled raw or burnt marijuana.
He
Because
didn't testify to that?
he didn't, it's not specific whether it was raw or burnt. He just said strong odor of marijuana. And having just admitted to smoking outside the vehicle, certainly there would be a strong odor of marijuana.
Well, Attorney Nelson, I guess my reading of the record is a little different because I paid very close attention to his testimony. And his testimony says we had a strong smell of marijuana, and he went to talk about like it was in the area, it was on him. And we asked if he was smoking marijuana.
Yes.
So we asked if he was smoking marijuana. I think, I don't know, it seems as if the inference there is that he smelled burned marijuana.
Yes,
And all the testimony from the officer thereafter is also about smoking marijuana. There's never any testimony that would be tied to raw marijuana or you know, a smell of raw marijuana.
yes, I absolutely agree. I completely agree with that. The inference is absolutely that this was burnt marijuana, which limits the scope of the search of the car. Under State v. Ferris, the odor of burnt marijuana doesn't provide probable cause to search the trunk. And that's
And
all
was
we
there
have.
and then that leads to the next question is whether there was any challenge with regard to his qualifications of being able to discern burnt marijuana.
So not an explicit challenge after the testimony. That particular factual point was not raised, but I don't think the issue has been waived because Moore and Ferris were heavily relied on by defense counsel in arguing the motion to suppress. The state argues that In Re AT suggests that this issue could be waived, but in Re AT, this court was very clear to note that the probable cause to search the vehicle was not adequately preserved. There was a one-off line that says the defendant submits that there would be the state cannot prove that there's probable cause to search the vehicle in this case. That's not what we have here. We have well-developed arguments under the authority of Moore and Ferris. And because Moore's holding specifically puts an officer's qualification and experience in detecting the odor and smell of marijuana as a factual predicate to finding probable cause, I mean, I don't think you can excise that qualification from the probable cause finding under Moore.
Are you distinguishing AT, or are you saying AT was wrongly decided?
In reply, I argued that it was wrongly decided because of it's the state's burden to prove that the search of the vehicle was proper and supported by probable cause. And to say that it was waived when we're specifically challenging the search of the vehicle under the authority of Moore, I think is disingenuous with regard to the Ohio Supreme Court precedent. But this court doesn't even need to reach that after additional review, realizing that the real problem in Re AT was the probable cause matter wasn't well developed. But I think here is distinguishable, it was well developed. With the exception, obviously, that specifically saying there was no testimony that he's qualified to detect the odor and smell of marijuana. We don't have that in this case. We do have Moore, the State v. Moore case that was repeatedly relied on in the motion and in argument to the court.
Thank you, counsel. You still have your 3 minutes.
Thank you.
Thank you. Attorney Woodall, good morning again.
Good morning, Your Honors, and may it please the court. I would submit to the court that what was argued during the motion to suppress and in the arguments to the motion to suppress was solely the search of the trunk of the vehicle. In counsel's brief that they provided to the court after the fact, they specifically said that they're not challenging the initial interaction with the officer, that was illegal in any way. Rather, it's just the search of the trunk that was what was being sought to be suppressed. So I would submit to this court that that is not the issue that was before the trial court in this case. But if this court were to find that it had been preserved by that initial, what I recall being boilerplate, but I also would have to check on that motion to suppress that was filed by defense counsel, I would submit that this was initially, a consensual encounter. They walk up to him, they ask him questions. They don't say, hey, we need you to stop. They say, hey man, do you live here? They ask him, were you smoking marijuana? And he readily admits.
Well, I
At that-
find it interesting, though, that the officer uses the term confronted. And that's how he characterizes his engagement with Mr. Ulmer.
And Judge, I think that you can confront someone and not stop them. Would be what I would argue, that he might have used the words confrontation, but if you look at what is on the body cam, it's not what you would think of, you know, a traditional stop, like, hey, stop, I need you to stop. It's, hey man, do you live here? And there's nothing that I could see in the body cam that would suggest that he wasn't free to leave at that point in time. But if this court were to find that, you know, they were stopping him, they smelled marijuana, they smelled it coming from the car, it was strong, they would have reasonable articulable suspicion to believe that he was committing an offense or had committed an offense sufficient to stop him for Terry purposes. And getting to the search of the vehicle, you know, the initial search of the interior compartment of the vehicle was based on the smell coming from the vehicle, the smell on the defendant, and the possession of marijuana that the defendant had. And when Officer Ruberg was searching the vehicle, he found a marijuana joint in the vehicle on the right front passenger. What is that called?
The interior compartment is what I understand.
On the
Yeah.
side door, on the side, the passenger door. And, you know, I think if you look at Ferris and you say, sure, you know, the smell of just burnt marijuana is insufficient to search a trunk. Well, we have more than that. We have this additional contraband that was found inside the vehicle. And if we look to Braxton and Greenwood and Price, which I cited in my brief, those all stand for the proposition that the smell of marijuana combined with some additional contraband, whether that's marijuana, whether that's paraphernalia, in this case, whether that is this joint that's in the vehicle, that is sufficient to then search the trunk of the vehicle.
Well, here's the question that I need some clarity on, okay? Because when I look at these cases, you know, the rule of law is that the search is confined to the object that is, you know, that's the object of the search. So it's confined to compartments that can contain the contraband that's the object of the search. So in this case, the object of the search is burnt marijuana. And so the officer finds burnt marijuana, which is the object of the search. So how is it that finding the object of the search then opens up the door to continue to look into other areas such as the trunk, which, you know, how do you distinguish it from Ferris is what it comes down to.
So I think it comes down to just finding that contraband. So because there's that contraband in there, there's probable cause to search, believing that there could be additional contraband in the vehicle as a whole.
But the contraband is burnt marijuana. So even if your rule of law was accurate, we're still limited to compartments that can contain the contraband that's the object of the search. Now, this is very different to Vega, and I think you cited Vega in your brief, because in Vega, the object of search was raw marijuana, and then there were other things that were found along the way. So in essence, the probable cause changed and morphed as the search went on, that then allowed for other compartments to be searched based on what had been found. In this case, it is the object, the contraband, that's the object of the search that is found.
And I agree to the extent that if this had been a case with raw marijuana, which looking back at the body worn camera last night, it appears to be a small burnt joint, that if it were raw marijuana, this would be a much easier answer. But I would submit that if we, you know, in the Greenwood case from the 2nd District, the officer saw marijuana on the passenger seat and floorboard, which provided probable cause to search the entire vehicle, including the trunk. So it would be, what I would analogize it to would be if an officer were searching a vehicle without, you know, a smell of alcohol and they find an open container, that would then give them probable cause to search the entire vehicle, including the trunk, because there is that additional illegal contraband inside of the vehicle. So I would submit to the court that it is that contraband that in this case is the raw marijuana joint that does give the officer probable cause to expand the search of the trunk.
Because in Ferris, they didn't find anything in the
Right.
passenger compartment.
And it was
Right.
just the odor in Ferris. So if this had been a case where it was just raw marijuana odor, we don't find anything else in the car, no go, the search of the trunk is bad. But in this case, because we do have that extra contraband that was found, I distinguish this case from Ferris and you know, say it's more like the Braxton, the Greenwood, the Price cases that I cite that does give the officers then additional probable cause to search the trunk. If they're
And what about the argument that the state didn't elicit from the officer his qualifications to detect the smell of marijuana?
That's true.
Is that not on the state?
I would submit that, yes, that is on us. That question should have been asked. It wasn't. The LT case, I think is on point that it wasn't raised. Whether or not it was raised or wasn't raised, I think doesn't impact the ultimate outcome of this case. As you know, Judge Zayas pointed out, he admitted to smoking marijuana inside the vehicle. So you can infer that it's burnt marijuana. I think it doesn't necessarily matter in these particular facts, whether it was raw or whether it was burnt. Because even if we just have the burnt, you can still search the car, you find the contraband, and then you can search the trunk. Would I have liked them to ask those questions? Yes, but they didn't.
But this is, to your point, this is a situation where Mr. Ulmer admitted it was marijuana.
Right.
So we're not left to question what the smell was because he admitted what the smell was.
Right. And if we hadn't had that additional contraband like we talked about, and it was just the burnt marijuana that we're smelling, and we wanted to search the trunk, certainly we would have needed to present evidence that there was raw marijuana. But because we found the contraband in the vehicle, it's really not relevant whether it was raw or burnt. And if there are no further questions, I rest on the merits of my brief and ask this court to affirm.
Thank you.
Just to answer Judge Myers' question about the boilerplate motion, it was rather boilerplate. There were like 2 sentences to summarize based on the facts that there wasn't a proper ferry stop, but for all intents and purposes, it's pretty.
Yeah, and when I meant boilerplate, really what I meant was a recitation of the law as opposed to an application of the law to the particular facts of the case. And I mean, that nothing, didn't mean to imply that boilerplate was somehow deficient in some way. It's just that if you put in the law of the Fourth Amendment without applying it to the specific facts, that's what I meant by my question. I think that's exactly what you answered. So thank you.
Right. Yeah, I mean, they do a factual recitation, but it's not, the law, you can obviously decide for yourself if it's sufficient, but I think that for what you were asking in terms of whether or not this issue was adequately preserved, I still think that it was put forth adequately, but I can see where the court might find that it wasn't sufficiently, or may have been forfeited later down the line. But one last point I would like to make with respect to the vehicle search and the trunk search specifically. The cases cited by the state where that allowed the search of the vehicle had what I call marijuana plus. So they had marijuana plus other illicit drugs, like cocaine, prescription drugs, other things that made it readily obvious that a search of the trunk was warranted. But as you pointed out, Judge Zayas, we have burnt marijuana in this case. The whole scope of this search was about burnt marijuana. The object of the search was obtained from the vehicle. There's no further justification to get into the trunk, respectfully. Even in the case, I think it was State v. Price, where it was mostly just marijuana, but there was also a wad of cash, some nervousness, some furtive movements, and additional things that made the officer more heightened to maybe there's more into this car than marijuana. And we don't have facts like that in this case. Everything happened outside of the vehicle. Once they got into the vehicle, they found what they were observed, what the smell that they had observed, which was the burnt marijuana. And I think under Ferris squarely, we don't get into the And on that basis, we'd ask this court to reverse if there are no further questions.
Thank you. Thank you for both of your arguments this morning. We'll take the matter under submission, issue a timely decision, and I wish you a wonderful afternoon and keep safe.
Thank you,
Thanks.
you too.
Take care.
Good morning. Can you hear me?
We can. Are you choosing to come in with no, oh, there you go. Okay. Good morning.
Good morning.
I was waiting for you to be fully online.
I have a little technical difficulties. I'm a little backward that way. But thank you. I apologize for not being,
No, you're fine. You're coming across clearly and everything.
thank you. If it
And
please the
Attorney
court,
Adams, of course, you're coming across very clearly as well.
thank you.
Oh, you know what? Is your audio off? Because,
No, I can hear.
no, Attorney Adams.
No.
Okay,
we
no,
don't
okay.
have-
Because it seemed as if you said something and I didn't hear anything.
No, I'll go ahead and mute now though, okay?
Okay, well, good morning to council. So we're now here on the case of State v. Powell. And as we normally do, if you can go ahead and state your name and readiness to proceed.
H. Louis Sirkin. I'm representing the appellant, Catherine Powell. And
Good morning.
if it please the court, this matter is before the court because the lower.
Let me
court-
just give Attorney Adams an opportunity to introduce herself as well.
Excuse me.
Hi, Paula Adams on behalf of the state of Ohio, and I'm ready to proceed.
Thank you.
We're now ready.
Okay, we're ready.
To please the court again. I'm here on behalf of Catherine Powell, who was convicted of telephone harassment pursuant to Ohio Revised Code 2917.21B, specifically for making a couple text messages on May the 26th of 2019.
Attorney
Ms.
Serkin,
Powell-
would you like to reserve some time before you proceed
Yeah,
further?
I'd like to reserve 3 minutes.
3 minutes, okay.
Thank you. Ms. Powell had a child with an individual by the name of Ryan Haynes. The child reached the age of 3 on May the 26th, 2019, and there was no acknowledgement of the birthday by the father. They are not married. It was a child born out of wedlock and a very short duration relationship between the two. The child has some birth defects, one of which is with his feet, and another was recently diagnosed about the time that this incident occurred with some brain lesions and some other difficulties. He's been constantly under the care of Children's Hospital in Cincinnati and both Children's Hospital in Dayton. The mother is solely taking care of the child over the years, over the 3-year period. It attempted to try to get the father involved, and he simply would not. And it reached a period of just utmost frustration on the evening of May the 29th at about 10:30 in the evening, when he had not even made a call or any inquiry or sent a card or did anything in relation to the child's birthday. She then sent a text message, which is exhibit number 1, which had some unpleasantry in it, at first in describing what she felt about him, but that doesn't constitute harassment. That wasn't the purpose of the call. The purpose of the call, or the text included a video that she had made that documented the 3-year development of the child. There were videos from his first birthday, his second, that were combined in one. And she really was making it an invitation to him to take a look at the video with the hope and the purpose that he might now become interested in playing a role of the father. He wrote back.
Mr. Sirkin,
Yes.
Mr. Sirkin, can I ask you something? If
Yeah.
it had stopped there, maybe that would have been the end of it. But even after he blocked her, she continued to try and contact him after he made it clear that he did not wish to be contacted anymore.
But
Right.
again, her purpose was that the follow-ups after the blocking of it came the next day. On the 27th is when he sent her an email later in the day. There were several text messages that were never proven to be from her. And the court ignored those and said that she was striking those from the evidence at the end of the state's case when they went to introduce all the calls that alleged, or all the texts that had been sent. So from Catherine, there were no messages that were related to her other than the two that occurred on May the 26th, one inviting him to look at the tape or look at the video, and the second to respond a follow-up one saying, please unblock your number, Ryan. There is information I do need to get. She was asking, which has been constantly a problem and has been and had an ongoing hearings in juvenile court as to whether he was in contempt for failure to provide her with proof of medical insurance. And so,
just so I understand which ones were not entered into evidence. So there was a point in time where he blocks her number and then she contacts him from some other number.
no,
right?
There's no proof that she's the one that made those contacts from any other number. I included all the 11 pages of the exhibit so that I would put it in as a whole. But the only ones that the court considered was the one marked exhibit number 1, number 4, number 7, number 8, number 9, and number 10. And number 10 and 11, the 11th one, the very last text, which was, and at the top of the page, it says May 30th, and it says 2103, and that meant on 2103 time on May the 30th. So there were two texts before on the 26th, and then there was a follow-up text by her on the 27th after he had asked her to stop calling or contacting him. The text on the 27th then began to relate to, I need the insurance card. This had been a perpetual problem. This had been an ongoing problem between the two of them, which was pending in juvenile court. And he had been found in contempt, and he was on a period of time that he could purge the contempt by supplying the card. He had, and one of the other things that she had had difficulty with them was getting a current address to be able to send him any motions for hearings before juvenile court. So that there are a series of texts in there that were not considered by the court. So as I say,
So in effect, the ones that, when you attach these texts, the ones that have an X marked across them were ones that were excluded, and we should not even be considering them in any way, shape, or form.
Correct, but I
So
didn't.
So it leaves us with the initial text, which you had described about the video with regard to on the date of the birthday, which had some unpleasant language in it. And then from there, we skip forward all the way to the request for the number to be unblocked.
And
that talking about that she needed the insurance card, right?
Did that on the 27th, and then she followed with a request on the 27th after he had sent that, saying, by court order of the law, you're the father. You're required to give me that. You're to give me that in your street address, so that she'd have contact. She was under the understanding from the hearing that had occurred a week or so before this charge came about with Judge Bender, that she understood that she was allowed to communicate with him by either letter or message if it relates to the child. And so that's why she sent, and in her mind, sent that text back to him on the 27th that I still need the insurance card and I need a current address. Then
so Attorney Serkin, I just want to ask a question, if that's okay, right? So she does the initial text, then she requests to be unblocked. He responds with the ORC and asking for her not to contact, right?
The following day.
And then following that, she's talking about the insurance card. So my question is this: by requesting for there to be no further contact, and then an individual contacting thereafter, whether that is enough to be violative of harassment under this statute?
I don't believe it is, because she wasn't charged with not, making a call after she had been directed not to make a call. And she was under the understanding that she was allowed to communicate to him if it regarded the child. And that's what she was following up with after he said, I don't want to hear from you. She felt that it's okay for me to make requests and to follow up on anything that relates to Sebastian. That's the child's name. And that's the only reason. He even testifies that he says that, all her calls and anything between the two have always been in relation to inquiries and matters dealing with the child. Now, I mean, I know it's not a matter of morality or whatever, what his moral obligation may or may not to be, but the offshoot of this is if one parent decides to call. My wife calls me and complains about something my kids did today, and I take that as being harassment, and I say, don't call me back anymore in relation to anything with the kids. And then she does, and I go run to the court, and say that I'm being harassed by the phone calls from my wife regarding the behavior of my children or some problem with my children when I don't want to be bothered while at work. I mean, nobody would, it's just.
But isn't the difference, I mean, we have to look at the entire background in this case. And to me, disregarding the email or the text that have the X's in them, he keeps writing to her, please stop trying to contact me. Please stop trying to contact me. And she continues. And don't we have to look at the entire background of this case, that this was actually in court already? So this is a situation that could have been dealt with in court. And he's saying, don't contact me via text. So doesn't that kind of the circumstances demonstrate that there was a harassing intent there?
I don't think so. And it's her specific intent and purpose. It's not what he feels from the calls. All she's really doing is that she's really hoping to have this person take a participation in the development and the raising of a child, to visit him, to whatever else. And yes, he's saying, I don't want to have any, he openly admits, I don't want to have anything to do with the child. That's not, I would think, is something very difficult for one to accept. I don't think she's, again, going for a specific person to harass him. It's almost like begging him to please, will you please reconsider? I want you, and I believe that Sebastian is entitled to have you part of his life.
But hasn't he made clear that whether that's a noble thing or not, he's not interested in it? And couldn't a trier of fact conclude that her purpose at that point was to harass him?
I find the totality of the relationship and the nature of the calls dealing again with the child, I still think that that's not enough to consider. It may have bothered him and it may have put him on a guilt trip, but to say that's harassing him to please accept the role of a father, I think is contrary to what the law was intended to mean. I just think that taking it to its furthest extreme with this and the application of this law, perhaps it should have been diverted, and the police department should have diverted it to a social agency or recommended he deal with it in juvenile court where they have pending matters that are dealing in relationship with the insurance card. Why he never gave her the insurance card is hard to believe. He was working for a fire department and a state agency. He worked for the city of Woodlawn or the village of Woodlawn, and not to have that and to play games with her about the card and to say, well, that's my employer's responsibility, you're providing no information at all. I don't think, because he felt that he was bothered by these calls or these texts, she's only acting in response as a mother would, I would think, in relation to a child in trying to make him, accept the role as a father. And I have a difficult time believing that ultimately can be transferred and one can take from that a purpose of harassment.
And Attorney Serkin, I have the same sort of question that in my head that Judge Myers, I believe, has, but I guess she'll tell me if it's different. And that is, ultimately this was charged as under harassment. You're going to, the trier fact, which was the trial judge was looking at the totality of circumstances. So once she looked at those totality circumstances, made the determination that this was harassment, aren't we subject to abuse of discretion? And so, how do we reverse that? Is there a case that you can point to that would be helpful?
I think that there are several cases. I think that one is I think I've cited them, but I think one is the one, I think this court I know dealt with it back in 2018, Your Honor did. Judge says that you had written, I think, in the Ham case, but that was an alleged threatening call. But I think it's one of the cases I think is State versus Dennis, and then there's State versus Davidson. And there's a case out of I think the 12th district. Oh, give me a second, I'll find the cases.
Yeah, and the Ham case, if I remember, that was an issue of threat. That was under the threat portion of the statute, not the harassment.
One is State versus Boniface, which appears at 91 Ohio Appellate 3rd, 2008. It's a 1993 case, excuse me. It's out of the Third Circuit, not the Second Circuit. Another case that I think it's helpful, well, as I indicated, it was the Davidson case.
And while you look for that, I have a second question. And in reading the briefs, it appears as if there had been a prior, or possibly more than one prior charges that had been dismissed. Was
Right.
that part of the record? Was that made part of the record?
There was discussion about it and there were questions about it, and they all agreed. There had been a criminal trespass right after the child was born or when she was pregnant that he had filed. Then he filed an affidavit for a protective order in Common Pleas Court that went before Magistrate Judge Brotman, that he threw it out. And then there had been, when she was calling the fire department to find out his home address so she could send him service for a motion to compel him to supply her with the insurance card, he filed an harassment charge that had been tried and she was found not guilty.
And all of this is part of the record. Is that right?
It's in the record. It's in the
Okay.
record of those, those had been filed. As a matter of fact, Judge Brotman really gave him sort of a lecture when he threw out his request for a protective order. So he has been, he just immediately, because of his involvement with the fire department in Woodlawn, I mean, really, he's just knee-jerk reacts at anything that she does that maybe makes him feel guilty. But being made to feel guilty, I don't think is harassment.
But if you've been told 2, 3, 4 times, don't contact me, don't contact me, don't contact me, and your argument, I think, is not that she wasn't doing it for the purpose of harassing him, but rather to try and get him to change his mind. At what point in time is it clear that he's not going to change his mind and it becomes harassment?
I don't know. It's very hard for me to put myself in that place, being a caring father and an involved parent, that someone who at some point so blatantly would totally refuse to accept any responsibility other than a monetary to helping out the raising of a child. And I don't know that by consistently and being persistent with that and giving him an opportunity, perhaps could save him some difficulties later on as he grows older and may tend to regret not taking an active part. I don't know that becomes harassment, and I don't know that mother instinct would stop someone. She's not, there's nothing physical being done. It's again always in relation to please become a part of our child's life. That's all she's really asking for from him. And I know he has positively said in whatever, and perhaps they should have been diverted to counseling, and maybe juvenile court should have taken a more active role. But to put on someone now a prior conviction, which in the future, if there becomes an ultimate need for her to have to make contact with him on an immediate basis, she could potentially be facing a felony. And
Thank you. Thank you.
Well-
Attorney Adams,
Good morning, Your Honors.
good morning.
I think that the gist of this case, there's no specific number of communications. It's just the facts of this case. And I think Judge Bender, at the end of hearing all the evidence in this case, was very clear that the tone and tenor of this matter, as well as the surrounding facts and circumstances, you can't ignore, the history between these individuals. All of that went into the trial court's consideration when considering whether or not that behavior met the elements of this offense. And certainly,
But was Attorney Serkin's characterization of the record accurate with regard to what the history was?
I believe so. And I believe, in fact, Judge Bender had herself presided over one of those prior proceedings.
Because if that, then taking that into account, if there's a prior history where it's unfounded, then how is it that calculates into harassment?
Well, I think that it gave the trial court a clear indication, as Mr. Serkin has indicated, that the defendant's motivated by, and I believe it was the trial court's language, trying to pull at his heartstrings. And the trial court was certainly very cognizant of that. And I think, in fact, she kind of felt bad for the defendant, and to a certain degree, that was clearly her intent here. But when we look at the facts and circumstances regarding all the communications that were before the trial court in this matter, that it did amount to, at that point, harassment, and the trial court then found her guilty. I don't think that she improperly considered the previous. It was just after the finding of guilty was explained to her, hey, you're involved in juvenile court, that any communications that you have with regard to the medical coverage, all of those things have to be handled in court. And I think that was the trial court's and her purpose in referencing that prior matter was indicating that we know that you're already involved in juvenile court. There isn't a reason for you to go on your own and make these allegations of saying, you're in contempt because they're already involved in court. So I think that at the end of the day,
but ultimately, and this is what I would love to have some clarity on, ultimately, she's asking for a medical card. She articulates that he had agreed that there could be communication, written communication. So she's asked, there's a change of address that had not been taken to the court. So she's asking for the address in order to address the medical card. So she's basically communicating on something that she has sort of like lawfully, I'm going to say lawfully, that it's, that she is, within her rights to communicate on. And so when she's communicating on something that she's within her rights to communicate on, and he's saying, I don't want that communication. I don't want that communication. Stop, stop, stop. And she's continuing to communicate on something that she has rights to communicate on. It seems as if what we might be saying is like, look, instead of trying to work things out on your own, go file contempt. Because the alternative to this is she goes files contempt. You didn't give me the medical card. You didn't give me the address. So it's almost as if, the alternative is to encourage, folks like this to just go to court and file contempt.
I don't believe so in this case. Again, if that were an isolated incident where she's just saying, hey, I know you're not living at that address, or hey, I really need the updated medical card. But that wasn't, again, this is coming on the heels of that video that she sent, calling him names and whatnot. This is all, again, we need to look at all the surrounding facts and circumstances. This wasn't and then, him blocking her, and then it turns into these legitimate communications. So I
Right,
think
but there's
that
only
at the
one
trial court-
communication before that. There's one communication, the blocking, and then after that is the legitimate communications that he's saying, I don't want to hear. So, it
Well,
sounds almost
subsequent
like
to
the
him
rule of
telling
law
her.
is,
Yeah.
hey, if you're getting legitimate communications, but you don't want to get them, and you get them anyway, then that's harassment.
Well,
That's, and we're not
again,
talking about civil harassment, we're talking about criminal harassment.
right, but I think, again, we have to look at all of the communications and all of the surrounding circumstances between these two individuals that were before the trial court, instead of parsing them out one by one. And it wasn't, they turned into that legitimate forms of communication after he had said, don't contact me. And then she said, well, here's the reason now that I'm contacting you. So I think that when the trial court looks specifically at, the transcript of the proceedings in this case, Judge Bender certainly was cognizant of that and made her rulings on some of the other communications. So even taking those out, thought that the intent was clear in this matter. So we'd ask that it be affirmed.
Thank you.
And just brief rebuttal on that, she was acquitted by Judge Bender for the calls that were related to her child or whatever he was complaining about at that time. So she's free. It's okay to go ahead and continue those communications, and that's what she did. She didn't call him, she sent him a text. And it followed on that same line afterwards. The only thing that is unrelated to anything that had not the communication was the criminal trespass that had happened 3 years before. And so she, taking from what her purpose would be in the feeling that because I was okay and found not guilty before, I can continue communications relating to Sebastian and his medical condition. And again, still asking about the idea of him giving him the opportunity to be a father. And I think that—
Well, how about though, when he texts her the language of the statute and cites her to the statute and says, stop, you're in violation of this.
He claimed the last time that he had used that same one and she was found not guilty of a similar charge. And so, it's again relating to the child. Again, a parent to say that you absolutely cannot communicate to me about a child. And if you do, because I ask you to stop, and that creates a criminal act. He wasn't charged under that section. The police, when he went to Springfield Township, is where he swore out this charge, and they did it under the B1 or the B2 section. So what takes away the idea that her purpose was other than the fact to communicate in regard to the child and was not with any specific intent to harass?
Are you arguing
What about
that
when—
if you have, if all of your communications, if it's between two parents and it's all about your child, there can never be a harassment charge?
Well, I think that it makes it, in my interpretation, I would think that unless there's some threat connected to it, in the sense I'm going to do something physically to you, I don't know how you can tell parents that they cannot communicate for the purpose of relating information.
But that would be menacing, right? If there was some kind of threat.
Perhaps be menacing or stalking.
So any kind of communication between two parents about their child, if one parent says, stop contacting me, are you saying it can never amount to harassment because it's about the welfare of the child?
I think that if it deals with the welfare of the child, I would think it's awful difficult to say that becomes harassment. Like the example I gave in my opening portion, where if my wife calls me and is complaining about the children, and I say, don't bother me, and I want you to stop calling me about the children, and she calls me back, and I decide to file a phone harassment charge against her, what the reaction of the court would be. I find that—
But you're talking about a married couple.
Well, but
And in this case, they're not married, they're not even in a relationship.
But they're a mother and a father of the same child, so there's a common bond between the two. Regardless of the fact of whether they're married or not married, they're both parents. It took two children to have two adults.
But isn't the question we have to look at, what was her purpose in trying to contact him? And if we would find that if somebody says, don't contact me, don't contact me, don't contact me, and in a short period of time, there's continued attempts to contact, isn't that evidence that it was her purpose to harass, not to talk to him about the welfare of the child?
Not if a week before a court said you're not guilty. I mean, it follows on the heels of being found not guilty of a similar complaint when she was trying to find out information about his address in order to send a motion to come in and show why he shouldn't be held in, to show cause why he shouldn't be held in contempt.
But what does that have to do with her purpose?
Her purpose is, again, to get information and to try to lure him to be attracted, to be an interested parent. That was the purpose of the video. That's why she made it. She did a chronological video of the child to say, here, this is your son. Please be a father. That's what she's asking for. She's not asking to harass him. I don't think that if he feels any guilt from it, guilt isn't harassment. And I think, you know, in really society should demand, in a sense, that if you should be put on the spot if you're not accepting the responsibilities of a parent.
Thank
I
you.
think that even taking the weight of the evidence on this ultimately is a miscarriage of justice and the finding that the court came out with in this case. And I ask you to please reverse it. If you do it on the weight of the evidence, it would be remanded for new trial. Sufficiency of the evidence. Again, there was no evidence in direct that there was any indication of a purpose, in my opinion, to harass, and should have been the finding of the directed verdict should have been granted.
Thank you for both of your arguments this morning.
Thank you.
We'll take the matter under submission and issue a timely decision. And have a wonderful afternoon.
Thank you.
Thank you.